Hello, everyone. This is Tom Fox, and welcome to a live edition of Everything Compliance. Today, we're going to take up a variety of topics, and we're going to go geographically north to south. So that means Matt Kelly batting first, Jonathan Mark second, Karen Moore third, and myself batting cleanup today, a rare honor for me. So, Matt, what is on your mind this week?
Well, I wanted to discuss TD Bank, which, as many listeners might know, settled a huge anti-money laundering case with the Justice Department and many banking regulators last week, where, if I can remember it all correctly, TD Bank is paying a $3 billion penalty to an assortment of all of these banking regulators and the Justice Department. It had to plead guilty to conspiracy to willfully not fail to maintain an effective anti-money laundering compliance program. They are accepting 2 compliance monitors. And most interesting, and I'll get to this again shortly, they have a freeze on their assets and business growth at $434 billion, which was the total amount of assets TD Bank had as of September 30th. Just to be clear, so what was it TD actually did? They had huge and extensive anti-money laundering failures for years in the 2010s that let no less than 3 criminal enterprises funnel a total of more than $670 million through TD Bank for human trafficking, drug cartels, various other scams. These 3 were all operating independently of each other. They all just knew that because TD's bank's AML program was so weak, it was an easy mark to do their laundry work. And so they did. The drug cartel case in particular had 5 TD employees who were conspiring with the drug cartels in Colombia. We could go on and on about it, but it was an astonishing, long-lasting, far-reaching case of compliance mismanagement. What I wanted to, in particular, focus on were 2 things. First, I did want to circle back to this asset freeze because this is the second time in the last 10 years or so that we have seen banking regulators do this, where they put a cap on the size of the assets that a bank can have. For those not in banking, that is a painful thing because if you cannot expand your assets over time, the bank will have diminished earnings capacity. Diminished earnings capacity means the share price kind of wilts. And if the share price wilts, that means your equity compensation, if you're on the board or senior management, that can also take a hit. It becomes a real drag on performance. What is especially interesting here is that the regulator who did this, the Office of the Comptroller of the Currency, not only did they put the asset freeze on, but they said, if you, TD Bank, do not make your compliance program improvements in a timely manner, we are going to tighten that cap even more, where they're going to trim it by another 7%, and I think then go in 7% increments. Because part of the deal was that TD Bank, yes, they have to make a slew of AML compliance program improvements, but they have to do it over the course of 3 years in a 3-year corporate probation. So if they're not doing it, then they're going to feel even more pain. And I am struck because this is the 3rd time in the last 4 months that this particular banking regulator, OCC, has taken an action against one of the big banks, not necessarily for new compliance failures, although this is partly that, but more, you are not making compliance program improvements in a timely manner. So they did this with Citigroup, they imposed a new fine. They did this with Wells Fargo, where they imposed more restrictions on Wells Fargo's ability to launch new products, expand into new markets. And now we have this action with TD Bank, where OCC says, if you don't jump how high, and when we say we are going to increase the asset cap even more. It's really striking that OCC is clearly telling big banks, we've had it with your nonsense, that you can't improve your compliance program in a timely manner. With the Citigroup example, they imposed that new fine, I want to say back in August, for a previous settlement from 4 years ago, where Citibank is still struggling to improve its compliance technology and its compliance program. So there's a lot of that. And it's striking for regulate for customers in the banking sector, compliance officers in the banking sector, pay attention to what OCC is doing, because it is taking a very aggressive and muscular approach right now to compliance program capabilities. The second thing I wanted to call out with TD Bank applies more broadly to everyone, regardless of your industry. You might be wondering, how did TD Bank get into such a big mess? Well, because that was its corporate strategy. And that's the point I wanted to call out, is how a flaw in your corporate strategy could ultimately lead to a withered, atrophied compliance program. And that's the sort of thing compliance officers need to think about. With TD Bank in particular, the strategy was just, we're not going to increase the budget.
Excuse me.
That's it. That was the strategy, to make sure they're going to not invest in more compliance capabilities. So this was known, they had an actual name for it. It was known as the zero cost paradigm, or the flat cost paradigm. And it came from senior management. So for example, by fiscal 2021, TD Bank was spending less on its US anti-money laundering program than it had been spending in 2018. At the same time, the total amount of assets in the United States grew by, I think it was 38% to $559 billion. Net income for the US operations also went up to $4.98 billion. It's not like the company didn't have the money. They made a conscious choice that we were going to not invest in new compliance capabilities, even as the business grew. And now we're supposed to be surprised that that turned into a compliance meltdown for the ages. I'm like, what else did we think was going to happen here? And that has stuck with me a lot, especially for banks, because this is the second instance I can think of where management came up with a great strategy and ignored the compliance risks that flow from that strategy. And then they got bit on the rear end by a compliance disaster. Because that's really at the heart of what happened with Wells Fargo many years ago now, back in 2016. But they had their cross-sell metric was going to be their strategy for growth. That meant that tellers had to sell a lot of things to customers. 8 is great. You were supposed to sell 8 products per day. And because the employees felt the pressure to sell the 8 every day, they just started opening fake accounts, because that would count as one of the 8. And that led to all of Wells Fargo's compliance unraveling that we all now know. But yet again, that would be my message for chief compliance officers. When you talk with the CEO, when you talk with the management team, talk with the board, stop and tell them, can we consider the compliance implications of whatever our strategy is, and will they bring unnecessary compliance risks to us? And I will just close with one quote from the head of the criminal division, Nicole Argentieri. She gave one of the many speeches and press conferences when TD Bank was settled last week. But she said, for nearly a decade, TD Bank failed to update its anti-money laundering compliance program to address known risks. That was the whole case. That's the whole thing that went wrong here with TD Bank. They were growing, and they did not grow their compliance program's capabilities with that larger growth. And here we are. That's all it is. That is a story as old as time itself.
Jonathan, do you have your hand up?
Yes, Matt, where was internal audit?
Oddly enough, internal audit was, at least according to the indictment and other documents I've read, they were there. They flagged some of these issues, and they raised these audit findings and concerns. They, as well as some of the external people out there, such as OCC, this is a large bank, it gets examined by bank regulators every year. So internal audit, external examiners, they were both looking at the AML compliance program. They were both raising concerns, and then it went nowhere, which is another thing I have often said about what is a good metric for a poor culture of compliance. How do you know that management isn't engaged? Unaddressed audit findings that linger year after year after year. So internal audit was not nowhere, but when it's raised its findings, then they just kind of stalled out after that.
So,
Go ahead.
so if a suspicious activity falls in the forest, does it make a noise?
Apparently not often enough or not loudly enough. And I did also just want to say that the chief compliance officer at TD Bank at the time in the mid 2010s, they do not come off looking good here either. They are referenced throughout the criminal indictment from the Justice Department as Individual One, never a good nickname for a compliance officer in a Justice Department filing. But basically, this chief compliance officer, according to the Justice Department, they went along with the zero cost strategy. And they said, yeah, sounds fine. In their self assessments, they said, one reason I'm so good of an employee is I can put this into practice. They put the strategy into practice, but they didn't put a compliance program together that could keep pace with the risks. And it's an astonishing document when you read into what went wrong at TD Bank.
So do they survive?
TD, I mean, it's interesting because you get to these bigger issues about banks being too big to fail. I don't think they're going to go away, but they're going to be hobbled for years. You can look at Wells Fargo. I once tallied up the amount of money that Wells Fargo was spending on compliance consultants and fines and penalties and whatnot. They were spending $20 billion, I think, since 2002 to resolve various issues. And I'm probably understating that. But, the part that you could suss out from the 10Q filings, $20 billion. And it's an astonishing amount of money. Now, TD Bank, in some sense, their behavior is even worse than Wells Fargo. Wells Fargo got an asset cap, but it did not have that ratcheting function where if they don't make improvements, the cap's going to get even worse. So TD Bank has that. TD Bank has a punishment that Wells Fargo didn't manage to get. I didn't think that was possible, but here we are. They are the 10th largest bank in the United States. They've got 1,100 branches. So they're not a small bank. And I think, them going away would be a big deal. I don't think they're going to fail. In theory, maybe they could merge with a larger partner. In practice, there's all sorts of antitrust concerns there. I don't think regulators would want that. They really just want the banks to get with the program, no pun intended, that, you actually take your compliance issues and responsibilities seriously.
Karen, what are your thoughts?
Oh, I'm sorry. I should have raised my hand, I think. So, my thoughts is, kind of one of my many soapboxes, which is, in my experience, when I'm talking to banks, their compliance program is so focused on the regulatory or fiscal compliance, which tends to be very process driven, whether that works or not. And sometimes at the peril of implementing a good old basic fundamentals corporate compliance program that gets people to speak up, that assesses risks in an interactive manner, that make sure that you've got the culture there in which some of these things maybe, if they happen, at least don't bear fruit. So I don't know the specifics at TD, but I would wager that their compliance officer is not somebody who is grounded in the broader corporate compliance community.
Matt, how do you assess the double monitorship 3 years from the DOJ and 4 years from FinCEN? Or is it too early to assess that?
Well, I think it's probably too early to assess that. But it is yet another example of the costs of non-compliance here. That both of these people, whoever these monitors are, they are going to live rent-free in TD Bank's board's head for the next 3 years. As they go through, and they are going to do a soup to nuts review of the AML program. It is fair to say that TD Bank has brought in new leadership to the compliance function over the last year or so. They have hired several hundred new people. I suppose they will be hiring more. That TD Bank now seems to understand the gravity of what has happened here. But nonetheless, this is going to be a very expensive proposition. And everything they do is going to be under a regulatory microscope. Sometimes I guess the focus knob of that will be controlled by the monitors that are being assigned, but this is going to be a long and arduous improvement process for TD Bank.
All right. Well, moving south, Mr. Marks, I've had the privilege of hearing you talk about root cause analysis multiple times over the years. And I guess one theme that continues to this day is many compliance professionals don't understand, one, what a root cause analysis is, two, is how is it different than an investigation. So I thought I might ask you, could you explain the difference and maybe two or three of the top things that you, as in you personally, do when you do a root cause analysis?
No, it's a great topic, Tom. So, root cause analysis is really a systematic method used to identify underlying reasons behind a problem or an incident, such as a compliance failure or a fraud event, and to prevent its reoccurrence. So, if you do a root cause analysis, it helps understand why an event occurred. And that's where we get the why in root cause, beyond just what happened. So by identifying the root cause, rather than focusing on the immediate symptoms, root cause analysis allows companies to actually take corrective measures that address the true sources of issues, thereby improving overall processes, controls, and overall compliance. So, you talked about the difference between an investigation, what it is and what it is not. So root cause analysis differs from an investigation, which is focused on proving or disproving specific allegations, right? Investigations aim to find out what happened. A root cause analysis seeks to understand why it happened and how to prevent that from happening again. The word recidivism, right? You don't want it to happen again. It's not a risk assessment, and it's not a blame finding exercise. And by understanding the distinctions between the root cause analysis and other problem solving or compliance tools, organizations generally can use it more effectively to address those particular underlying issues and strengthen their overall compliance framework. Where I see real issues are, from a compliance perspective, I'll give you my top three. Focusing on symptoms instead of root causes, right? One of the biggest mistakes is stopping at the proximate cause of an issue instead of identifying the true root cause. So compliance professionals may focus on immediate symptoms, such as process failure or specific control breakdown, rather than investigating deeper systematic issues like cultural factors or ineffective training. Without identifying or addressing the underlying cause, again, future violations are more likely than not to occur. That's the recidivism thing. So that's number one. Number two is failing to ask the right questions. And I think this is really where understanding sort of I call it the cone theory, the left and right cone, where a business really operates and where it doesn't operate. But it does involve asking the right questions to understand these deeper issues. And compliance professionals often do not probe deeply enough, resulting in a sort of a superficial understanding of the problem. Take the 5 whys, for example. Asking multiple layers of why. This is why I talked about why before, can really help uncover the root of the issue. And then asking the wrong or shallow questions really does lead, in my opinion, sometimes to generally incomplete or ineffective or bad conclusions. So that's really number two. The third, I had to think about this because there are so many. I think the other one is something that I bark about all the time. It's really neglecting the human element of all of this. And I think many compliance professionals today tend to overlook the critical role that people play in overall compliance failures. I kind of stress that ineffective root cause analysis often ignore how individuals make poor decisions, actually circumvent or override controls, or fail to follow processes due to factors like, the enemies of controls, like incentives, or a lack of understanding or management pressure. These are things that we talk about all the time. Understanding that human behavior and the judgment and potential workarounds is key to conducting a thorough root cause analysis. So those are my top three. I have, a couple of others, which I won't get into in too much detail, but we can at a later date. and they're basically relying on data without context, I think is a huge problem. Failing to integrate findings into future deterrence or prevention activities. Even when a root cause is identified, sometimes compliance professionals often fail to take the very next step, and that is integrating those lessons learned into organizational policies, in the training and controls to actually deter or prevent future violations. So, avoiding these common pitfalls, so to speak, and taking a more holistic and questioning, or I like to use Socratic questioning when I do mine, compliance professionals and other professionals like internal audit as well can ensure that their efforts here lead to more effective remediation and the deterrence of future compliance failures. So I hope I couched that in the right and appropriate manner. I could talk about this all day long, but it is something that is pretty near and dear to me, and something that we like to practice on a regular basis.
Matt, do you have a comment or question for Jonathan?
Just a comment sort of to reinforce what you had said about understanding the human element of it, because so often it seems to me when I read these enforcement cases, that's really, such an important part of the root cause of this. There was one small FCPA enforcement action recently against an industrial manufacturer called Moog, where it had problems in its India offices. And it wasn't a huge FCPA violation case. I think they settled civil charges for 1.7 million, but it's not nothing. But if you, again, read through the actual documents of what happened there, it was a culture within the Indian subsidiary that didn't understand what they were supposed to be doing about ethics and compliance. It looks like they never understood why bribery was bad, or perhaps they were operating under pressure in their local economy there, where they felt like bribery was the only thing they could do to make ends meet. Were there loose controls? Yes, and those need to be addressed too. But I often say, if a person has decided to commit misconduct, they're going to find a way to do it, and I don't care what your controls are. So really, it's just such an important thing, is to think about this human element. And a lot of times we don't think about it because we don't want to face the awkward questions about management pressure, poor performance, inability to communicate clearly what we want, things like that. Those are difficult issues, but yet those are the issues that need the most attention.
Yeah, and the people process here, and that's what led me to enhance the so-called fraud triangle by adding competence and arrogance, is because it really is that human factor. And the one thing that really hit me when I was doing that research way back when was something that Joe Wells said. And Joe Wells, for those of you that don't know out there, he was instrumental in starting the Association of Certified Fraud Examiners. And I was with him one time and I listened to him speak, and he said, books and records don't commit fraud or pay bribes, people do. And when I heard that, it resonated in my big head like you would not believe, and I couldn't shake that. And I realized that he was onto something. And to your point, we live in a world, well, maybe not to your point, but I think over the years, our conversations, for anyone, we live in a world, unfortunately, where time is definitely an enemy of control, but we live in a checkbox type environment. And a lot of times people just overlook, or they glance away from these cultural issues or these people issues, or why they don't think that this is important, why they don't understand. And you can't overlay a control strategy in every single culture the exact same way. It has to be adjusted and modified accordingly. And people really need to understand that. And I think that's really the magic behind all this. The companies that I have seen over my career that have done a real nice job in this really do understand the sensitivities between, different cultures and how they may react to a policy, or, some type of control, or some type of supervisory review. And, and if you do understand that, you can put a control in place that really does help mitigate that. I think you're better overall, but a lot of the folks out there struggle to do that.
Karen, what do you have for Jonathan?
Yeah, just a quick question, with the companies that you're looking at, and to what extent are you seeing this hard baked into the internal investigations process? I like to say that when you complete the investigation is when the real work begins. You've got to take all of that and go beyond just the discipline and immediate remediation. But, go into that root cause analysis and make adjustments accordingly. But that's a big time commitment. It's a skills commitment. And even more so, I'm wondering, to what extent are you seeing that happen into the investigations process? So, like, to what extent is it part and parcel of the interview of the people involved in the misconduct? Why did you do this? Where was the motivation? Was it lack of training? Was the policy unclear? Were you experiencing your own personal pressures? Was there a lack of control that might have prevented you? And what are you seeing?
A lot of times you can get that through an investigation, that why. But remember, it's really an investigation is focused on proving or disproving specific allegations. So the investigation really is aimed to find out what happened. And if you are a skilled investigator and skilled interviewer, so to speak, or have those interview skills, you may actually figure out during the investigation, why something happened, or there may be more than one root cause. A lot of times that doesn't happen, and you need to embark on a separate exercise, and maybe it involves a different team that's a little bit more independent or has a little bit different insight than the investigative team. But it doesn't always, the answers aren't always there at the end of an investigation, unfortunately. They just aren't. And being the fact that if you look at today, everybody wants answers quickly because there are certain time constraints with regards to reporting now and things like that. You may not get to that why. You may get to one why or two whys, but you may not get down to that layer within the onion that really does give you that particular answer. And so from a remediation perspective, I think what the DOJ and what the regulators are really saying is, and I have said this before, I've told, and by the way, these are my comments, not BDO's, but I have said before that if you're an internal audit and you're making a recommendation, and you haven't done root cause, you better put a disclaimer in your report that says, we have not done a root cause analysis. Had we done a root cause analysis, the following recommendations may be changed, and they may be changed materially. But if you wind up doing it, a lot of times folks just shortcut the process, Karen, unfortunately, and don't do it properly, and they really do never get to that why. So I think I'm answering your question in a sort of a roundabout way, but it's not as easy as doing an investigation and assuming that the root cause is built into the investigation. It's not, but like I said, it depends on who's doing the interview, who you're talking to. A lot of times the people that you want to get to that have those answers are either not available or ex-employees, which are tough to get, or ex-business partners, which are tough to get, and so it becomes somewhat problematic. And a lot of times it's very difficult to get to the actual why. You may get close, but I think that's the aim here, is not just treating the symptoms, but actually treating the root cause, which is what I started out with when, I kind of started going through this. That is really the fundamental issue here. You bring up an excellent point, but for anybody out there that's doing an investigation that is a skilled interviewer, I do encourage them to ask those particular questions while you're going through, a certain areas. Why do you think this happened? Was it a process breakdown? Was it lack of training? What is the culture like here? All those particular things will help better inform you and probably give you a better root cause analysis if you didn't ask them along the way. So great point.
Jonathan, I would just add that the regulators have caught up to you because in some recent FCPA enforcement actions, the DOJ has specifically called out companies who began their process with a root cause analysis, then moving to risk assessment, then moving to remediation and all of the other steps, most specifically in the SAP case, but also in Gunvor. So this is now a requirement from the Department of Justice. And in a shameless plug for my soon-to-be released book, the FCPA Survival Guide, it's number 5 on my top 10 list. So you can check out the book, of course, but you can also contact Mr. Marks, who has much more information on it. So continue our moving south in the beautiful weather of outside our nation's capital. What do you have? Oh, actually, you have a terrible case for us. It's horrible. And I read it. And then when you said you wanted to talk about it, I said, absolutely. This is just beyond belief. So with that intro, Karen.
Okay, well, I hope that we're talking about Texas, although I have a couple of horrible cases in my back pocket as well. So no problem there. But in your beautiful state of Texas, Judge O'Connor, who is presiding over the Boeing plea agreement, on October 11th ordered follow-up from both parties on DEI issues, which I think came a bit out of left field for all the participants. Just want to quickly recap how we got there to begin with, just as a reminder, because this is has endured over the years. So, the whole thing really started in 2010, 2011, when Boeing was competing with Airbus for certain long range aircraft to meet customer demands. And so they accelerated their own development and production of the 737 MAX. That included design modifications requiring new software, that so-called MCAS that we've all heard about, and keeping the price competitive and getting the plane to market. There was a lot of pressure. Boeing ended up convincing the FAA to certify the 737 MAX edition, partly with an argument that the pilots needed little or no training on the new system because the operation was so similar to earlier 737 versions, which, as we now know, tragically proved not to be the case. And the faults in the MCAS combined with that lack of training resulted in two crashes: the Lion Air in October 2018 with 189 dead, and Ethiopian Airlines in March 2019 with 157 dead. Boeing was then charged with conspiracy to defraud the government as a result of their multiple false statements and representations to the FAA. Exacerbated additionally. I mean, we could recap this forever, but it was exacerbated by the FAA's actually granting of authority to Boeing as well to fulfill some of the FAA responsibilities. So Boeing in January 2021 entered into a 3-year DPA. It paid monetary penalties. It set up compensation for the relatives of the victims. It provided compensation to the airlines that lost money as a result of the grounding and the crashes, et cetera, et cetera. And it contained what we are now expecting to see, this attachment C to the DPA, which required some kind of minimal standards of compliance program. So you would think that Boeing would have hopped on that with all vigor, but indeed it did not, because in May of this year, people will recall the DOJ notified the U.S. District Court for the Northern District in Texas, which is overseeing the matter, that it had determined that Boeing had failed to meet the requirements of the DPA as it pertained to the compliance program, and that it was intending to enter into a criminal indictment. Subsequently, Boeing and the DOJ entered into a plea agreement pursuant to which Boeing would pay additional criminal fines and invest at least $455 million in compliance and safety programs, without any detail as to how that was going to happen, and submit to a 3-year monitorship, which monitorship was absent in the original DPA, but this monitor would be one that the government would select and oversee. And that proposed plea was submitted to Judge O'Connor for approval. Now, I'm not a litigator like Tom, you have been, so I don't know, but my sense is that these plea agreements are normally just accepted by the judge unless there's something really egregious in there that the judge might object to. But indeed, in this case, what the judge seems to have focused on, at least so far, in not approving the plea agreement, is some DEI components. And he's now ordered both Boeing and DOJ to file their responses by October 25th to some questions he had. And it's a really interesting order. It's only 4.5 pages, but it contains some, I don't know, things that are making me question. I don't know where he's coming from here. So I started to take a look. The plea agreement does indeed contain language regarding diversity. in the appointment of the monitor. It says the independent compliance monitor selections shall be made in keeping with the department's commitment to diversity and inclusion. That's all I found in the plea agreement regarding diversity for the monitor appointment. But the judge asked the DOJ to expand on what that commitment means during the October 11th hearing, and the DOJ prosecutor was unable to respond in detail in the moment. So Judge O'Connor actually commented that in response to the court's question on what the provision means in practice, the government explained it doesn't mean in practice that the government selects someone less qualified. Rather, it's going to hear from anybody who can submit from all over the country or elsewhere. I think that the prosecutor is probably a little perplexed by the question. Diversity in the monitor selection is actually set out in the March 2023 revised memorandum on the selection of monitors in criminal division matters, which the then criminal division assistant attorney general Ken Polite sent to all criminal division personnel. And I apologize for so many quotes, but I think it's really important to know exactly what both the order and the DOJ are saying here. And there is a section on the nomination of monitor candidates in that memorandum, which reads, consistent with criminal division's approach for the past several years, as well as recent department-wide guidance, which the judge gets back to, any submission or selection of a monitor candidate by either the company or the criminal division should be made in keeping with the department's commitment to diversity, equity, and inclusion, and without unlawful discrimination against any person or class of person. So yay, they're going to abide by the law. Corporate defendants should also expect that corporate resolution agreements themselves, whether guilty pleas, deferred prosecution agreements, or non-prosecution agreements that contemplate selection and imposition of a monitor team, as is the case here in Boeing, specify this requirement and commitment. And the memorandum actually then goes on to cite a number of cases in which this has been affected, including for Panasonic Avionics, Fresenius, Glencore, and others. So in the Boeing plea agreement, is this kind of a question of cut and paste formality? It's required by the memorandum that the plea agreement should contain a statement on diversity in the selection of the monitorship, and it does. But Judge O'Connor noted that he asked the government to elaborate on what the words diversity and inclusion mean. And an attorney provided some information, but actually said that they weren't familiar with the details of the provision and how it would be applied in this case. So again, I think kind of caught unprepared. Boeing had nothing further to add other than it was confident in the selection process and sure that the government was going to honor its own commitment. So then we've got, so I guess that's well and good. It seems like a legitimate question, but we get to the middle part of this order, which starts to raise more and more questions. So the middle part of the order has Judge O'Connor summarizing both the DOJ internal DEI policies, including its own DEIA strategic plan, which is really talking about hiring within the DOJ itself. As well as Boeing's own DEI policies, which are publicly available on Boeing's website. And he calls out Boeing's 2025 so-called aspirations, which include achieving an increase of Black representation in the United States among Boeing employees by 20%, and closing representation gap for historically underrepresented groups, something we're seeing large corporations try to focus on. But Judge O'Connor calls those out. In addition, Judge O'Connor noted that executive compensation of Boeing's executives is tied to their achieving DEI goals. So that kind of comes a little bit out of nowhere. Because he then goes on to point out that the whole purpose of the monitorship is to ensure that they meet these compliance standards. He quotes directly from the plea agreement for compliance programs and integration with safety and quality programs to prevent fraud from happening in the future. And then he says, and here's where I think for me, big question marks start to arise. He says, given this, i.e., the internal DEI policies for both the DOJ and Boeing, and the fact that the monitor's role is supposed to, improve the compliance program. Given this, the court needs additional information to determine whether the agreement should be accepted. He wrote that the filing should detail what role Boeing's internal focus on DEI impacts its compliance and ethics obligations, how the provision will be used by the government to process applications from proposed monitors, and how Boeing will use the provision and its own internal DEI commitments to exercise its right to strike a monitor applicant. So it's starting to feel here like the judge is concerned that a focus on DEI is somehow going to result in a less than optimal monitor appointment. One also has to wonder whether Judge O'Connor's viewpoint has been influenced at all by an inquiry earlier this year, I think in April, by the Texas Attorney General into whether diversity practices at one of Boeing's suppliers, Spirit, actually impacted the quality of their production. The AG instructed Spirit to release documents on its DEI commitments for an investigation that will examine, quote, whether those commitments to DEI practices are unlawful or are compromising the company's manufacturing processes. So kind of a disturbing inquiry on its own. I didn't find anything on the current status of that inquiry, so that remains to be seen. We're also seeing trends, the recent pullback from Tractor Supply, John Deere, and others from their DEI commitments. And then there's also the EEOC letters from the organization America First Legal that is challenging DEI practices at 30 major companies. That organization has also challenged eligibility requirements for fellowships and programs, including at Pfizer, and we've seen the law firm Morrison and Foster, among others, also pulling back from their commitments. So we're seeing kind of a disturbing trend here. The last thing that I wanted to point out in terms of influence on Judge O'Connor's order here is, we should note that the victims' families have expressed disappointment and dismay over the plea agreement in a very lengthy filing objecting to almost every part of the plea agreement terms. They noted that as regards the monitor, the DOJ had firmly rejected the appointment of a monitor in its DPA, stating that it had confidence in its own ability, including with meetings with Boeing, to monitor the progress of the DPA, which clearly failed. And the victims' families in their filing now object to the appointment of a monitor in a manner that doesn't involve the court, which is not being given the approval authority over the monitor appointment that I think an earlier draft had contained, or the families in this selection process. And I think it's interesting to note that Judge O'Connor's order here actually begins with a reference to this objection. So, query, should we be also reading the order as a way for the judge to accommodate those objections of the victims' families, or might he be using the objections of the victims' families to frame his own perspective here? So a ton of open questions. It's going to be really interesting to see what the October 25th briefings contain from both parties, and like so much in Boeing, watch this space.
Matt, question or comment?
Yeah, this whole thing from the judge is horse excrement there. That's all it is, folks. For the record, he is a George W. Bush appointee, and these days you have to note which judges have been appointed by whom, because that generally reflects on what they rule. He, in my opinion, is clearly taking his conservative beliefs and principles and trying to shove them into the middle of this. Let's puncture a few balloons. First, can a judge really try and muck up one of these settlement agreements? Typically, so far, the answer has been no, and we know this because about 10 years ago, Jed Rakoff, who is a district court judge in New York and rather well known, he tried to invalidate a settlement agreement with one of the big banks in the Justice Department. Justice Department and the bank both appealed, and the appellate court in New York said, no, you can't do that. This is an agreement between those two parties. And essentially, yes, the judge's job is to rubber stamp it, which is, okay, not the case in England, but we're not in England. Here in the United States, district court judges really are not supposed to be the activists that O'Connor is trying to make himself off to be. He clearly is just looking to needle people over DEI, which I guess he thinks is something politically correct about it that he wants to invalidate. Let's all just step back and follow his logic for a moment, that therefore, when, let's say 50 years ago in the 70s, when racism really was much more prominent and hiring minorities was much less of a thing than it is today, therefore we should have had more air safety then, right? Except we didn't. We have these days fantastic air safety, and his whole idea that planes are falling out of the sky because companies are too busy trying to find Black and brown employees, that's just preposterous, and it is logically inconsistent with reality. I hope that he gets over himself. I am deeply sympathetic to the victims here, the 346 who died in these two crashes and their families, and I can see why they might not be unhappy. They might not be happy with the Justice Department settlement, but come on, folks. O'Connor is just using that as a fig leaf to wave his little conservative anti-DEI flag in the middle of a court proceeding, and it should not be there. That's all.
I love it, Matt. I was seeking to give him the benefit of the doubt, but thank you for saying all that.
Why bother? Yeah.
Well, I will now tell you why you're both wrong. This is a fabulous opportunity for the Department of Justice. If I were the DOJ, I would file as long a brief as I can saying, you are absolutely right, Judge. We have a DEI policy, and here is why. Diversity makes the process better. It is diversity of thought. Now, that thought can come from diversity of gender, diversity of race, diversity of religion, diversity of national origin, diversity of whatever you want, age. Thank you, Karen. Anything. And here's why we think it's important to have diversity. It's because the Department of Justice has taken a very square peg of a standard monitorship and tried to ram it into a round hole of a fraud finding for lying to the DOJ about safety. Compliance, that's not compliance, that's culture. And the monitor needs to look at culture. They need to look at safety. They need to whistleblowers, they need to look at compliance. They need to look at a variety of issues, manufacturing, outsourcing, third-party supply chain, all of that. And the DOJ has not explained how the monitor is going to do that. So this is a fabulous opportunity, if the DOJ fully embraces it, to go ahead and explain how this is going to make this work. As to the concern that the court doesn't have the authority, the difference between the situation with Judge Rakoff and this are twofold. Number one, there was no criminal plea in the Rakoff case. It was a DPA where the penalty would go away after 3 years. Here we have a criminal plea, number one. Number two, there were no victims' rights available, no victims' families. And that's a public interest right, which the court can take cognizance of. The victims' families have said, we don't trust Boeing and we don't trust the Department of Justice. And the court is saying, okay, Mr. Boeing, okay, Mr. Department of Justice, prove to me that you can be trusted to protect the victims' rights and make sure this doesn't happen again. I think that the DOJ has a fabulous opportunity here to do that. But if they come in and say, here's our definition and here's why we're right, they're going to be in a world of trouble in front of this judge. They can fully embrace this. They can fully embrace ESG. They can fully embrace the entire process, which they have not done yet. It is not transparent. It is incredibly opaque with the premonition or with the monition, trust us, we know what we're doing. Well, they didn't quite work out with the first DPA for Boeing. And now we're at number 2. And if you want to throw Boeing into this, they laid off 17,000 people in the middle of a strike. How much is that going to help manufacturing or safety? So I think the DOJ should fully embrace this, fully take it on. And everything Karen said about the inanity of this, and you as well, Matt, is correct. But why not defend it? Why not say our monitorship program is better because we've embraced DEI? There may be a monitor, but it's the monitor's team. And a wide variety of diversity will make that team better. And Boeing needs diversity. And they've got to get this culture better. So I think what the court's doing is sending out a factual record. And if the DOJ can show to the court's content that they can do these things and satisfy the victim rights, he'll approve it. Otherwise, he may put conditions on it or do something different. So if I were the DOJ, I'd say, you bet, Judge, here we go. So that's my harangue for the day. Anybody want to comment on that, or should we just move on?
Go right ahead.
All right. Well, now that I've got my harangue out of the way, let's have some fun, because I have been thinking about TD Bank in the context of Caremark. Now, the largest shareholder derivative settlement based on Caremark to date is $985 million against Petrobras USA for the Petrobras bribery and corruption scandal. I hope DraftKings will put some odds up on whether TD Bank can outdo that. Because if there was ever a case that seemed to cry out for Caremark analysis, it was this case. And I went back and looked at some of the original language of Caremark. In Caremark, the court began by noting that director liability for a breach of the duty to exercise appropriate attention can come in 2 distinct contexts. First, liability can occur from a board decision that results in a loss because that decision was ill-advised or negligent. In the second, board liability may arise for an unconsidered failure of the board to act in circumstances in which due attention would have arguably prevented the loss. Now, what that means in place is if you make a really grossly negligent decision, you can be sanctioned. But the second part of that is if you had information and you buried your head in the sand and you got negative consequences for that, you can be liable. Now, this is the board's liability, not Caremark liability. And for those that think a board might not, or excuse me, a bank might not have Caremark liability, I would remind you that the second case under the Caremark doctrine was Stone and Ritter. And that was a bank case. TD America Bank is a U.S. publicly listed company. So we have that SEC oversight as well. But Stone and Ritter further refined Caremark to say directors have utterly failed to implement any reporting systems or information systems. That's a violation of Caremark. So did they have a reporting system? Matt, you correctly noted that in direct response to the question, where was internal audit? Well, internal audit was doing their job. And the third-party consultants were doing their job. They reported up. Now, did the board get that information? The criminal information reported that information went to the board. But also, did the board have systems or controls so that the information would get to them? I think it did. So I think there's Caremark liability almost on an unlimited nature here. But say the board didn't get the information. Say the ubiquitous individual one who is, quote, the defendant's chief anti-money laundering officer, and individual two, the bank's BSA or Bank Secrecy Act officer, didn't report that up. Well, that's the new prong of Caremark under the McDonald's decision, that officers can be liable. So if I were those two individuals, I would be checking my E&O coverage as an officer of the company, make sure I had coverage, because the McDonald's case was never appealed. So we have nothing further on that from the Delaware Court of Appeals, and that means it's good law. And so if you're a shareholder derivative plaintiff lawyer out there, I'd be starting to read these all of these settlement documents because this lays out perhaps the most egregious case of board inaction I have ever seen. Whether it's a flat cost paradigm or their head was buried into the sand. I even compared it to the China syndrome because that's how far I think their head is buried into the sand. It went all the way to China. So I'm going to be very interested to see what happens in a shareholder action. The DNO Diary, I'm sure, will have some interesting commentary for us, as they always do. Kevin LaCroix's blog site is great for DNO coverage. So I think that's going to be interesting. And there's one other point that I have to raise, which is the Canadian reputation for good banking and good regulatory oversight was completely eviscerated in 40 minutes. Now, I wish I could tell you I thought that up, but it was in the Globe and Mail lead editorial on this. And what were those 40 minutes? Where Merrick Garland and Lisa Monaco or Nicole Argentaria announced the enforcement action against TD Bank. So where were the Canadian regulators in all this? We don't know because we still haven't heard from them. So that's pretty cool. I got a double harangue in one. So any questions or comments on Caremark, TD Bank, or the role of the board? Well, that means
I just have one.
All right.
I hate to play devil's advocate here, but when it comes to transaction screening and money laundering, yes, there were definitely issues there, but I never have seen anything written about all the things that they've actually stopped. So, it's kind of an interesting thing. They're picking on TD Bank. Granted, I'm sure I haven't reviewed everything. I haven't seen any evidence. And again, this is my own opinion, but they're picking on TD Bank as if it was an absolute major failure. I'm just wondering, how much of this stuff they actually did stop with what they had to work with. And again, I'm just trying to play the other side of this, Tom. There's transaction screening is a funny game. It seems like every bank that gets into this trouble, we all say, how come they can't get this right? People have spent millions, if not, billions of dollars on people and technology and all that kind of crazy stuff. And, it still seems to be problematic today. I mean, this is not anything that's new in the world of banking. So it's kind of interesting to me that they're hammering on TD Bank. And again, I got no horse in this race, but I'm just wondering if there was any good that actually came out of this, stuff that actually did work. And that's my comment.
Tom, I'll just try and take one shot at this. I think, the big flaw with TD Bank isn't so much that they were trying to monitor transactions and not doing a very good job of it. They made a conscious choice to ignore wholesale large volumes of U.S. transactions. Well over 90%, I think it was, not well over, but 92% of domestic U.S. transactions were not being monitored during this period. And they chose to do that. It's not like they were trying and then doing a bad job. They made a conscious decision. We will not be monitoring this. And that's where the fraud went to. It's not that far-fetched of a scenario to game out if you are supposed to be a senior executive in banking. So I see the point that this is not easy. That is certainly true, but that is not the same as deciding you're not going to try at all, which is what TD Bank really did with its deeply flawed approach here.
So let me ask you a question. We all talk about fraud risk assessments and risk assessments all the time. These are our risks. These risks are covered by controls. Some risks aren't covered by controls. Some risks are higher. Some risks are lower. Here's a strategy that obviously it seems to have implemented and probably well known, throughout the organization. How does it go so long and nobody says, hey, your strategy and your process is broken? That's the thing that I can't reconcile in my head. I mean, if I took a risk assessment from an organization and I'm like, well, what are the things that we focus on? Oh, we're not focusing on that because we don't think it's a big risk. Well, if it is because the risk landscape changes, I might say, hey, you really better be, it's really something that you really should focus on. But I mean, it seems to me, Matt, based on the commentary here, and again, I haven't reviewed anything in detail yet. I've only looked at things peripherally. And I really want to dive into this, but I'm scratching my head a little bit, because how does all this time go in? The OCC goes in there, they have examinations, they have internal audit, they have a board, they have all this stuff, and how does nobody bring this up?
Well, that's another good question. So I'll go back to, some people did bring it up, like internal audit raised these matters, and I suppose we should ask, who is the one who brings it? Because if they're lower level employees, to a certain extent, they might be fearful about their jobs. They might not understand what is or isn't appropriate for a large bank to do. More senior level executives, well, you would think a chief compliance officer would bring this up. However, this particular chief compliance officer seems to have gone along with this whole scheme, part and parcel, which leads me to question their judgment. But nonetheless, they went along with it. They didn't bring it up because they were part of thinking this is what we want. There are some questions about, why did regulators wait this long if it was so bad? If OCC, for example, was flagging these issues in examinations, which it had been years ago, why didn't OCC take some stronger enforcement action or warning earlier? I don't know. I don't know if they were part of a larger coordinated thing where they didn't want to get ahead of the Justice Department in criminal action. On the other hand, let's also remember, a lot of the misconduct that was mentioned in TD Bank, like, that was not ancient history. Some of it was, but some of it was happening in 2021. Some of the deficiencies were happening in April of this year still. So it is both right and wrong to say regulators were acting too slowly. In some instances they were. In other ways, TD Bank was still doing this right up until, in regulatory timelines, like last week, 6 months ago. That was a blink of an eye. It's a big, complicated, messy case. There's nothing good about this.
No, but I think at the end of the day, if the compliance officer didn't go along with it and left the organization, or there were people that were leaving the organization, I go back to this same thing that I talk about all the time, is, that's not an 8K event.
Should have been, or it should be, in theory. I don't know yet what were the circumstances of this particular CCO when they left the bank. But if a CCO is going to leave because they think the compliance strategy is untenable, I wholly agree with you. That should be some sort of triggering 8K filing. I think that would be a great idea.
And I really do think that the regulators really do need to revisit that. And I don't know that it really should be focused on, a certain specific set of individuals rather than I think it needs to be expanded. I really do. If you look at what really constitutes an enterprise today and who's involved with that, you have the director or the chief audit executive. Chief audit executive leave should be an 8K event. Chief compliance officer leave should be an 8K event. The lawyers have a noisy withdrawal option, and that certainly might be, general counsel an 8K event. The regulators really need to focus in on that, because that will force the hand. I believe that will force the hand, or at least it should set up a warning flare to somebody to take a good hard look at, why this is going on. So that's all I have for today.
I hope not, because we're on to fan favorite shout outs and rants. We'll keep the same order. So, Matt, that means you get to go first.
All right. Well, I have both a rant and a shout out about the same thing that was happening in Boston today. The shout out is for our newest professional sports team. We have a new women's soccer team here in Boston. They are called Boss Nation Football Club. Boss Nation is supposed to be an anagram of Bostonian, although astute people will notice there's 2 O's in Bostonian and only 1 in Boss Nation. And that brings us to more of the rant part of this. I am especially pleased that we have more pro sports. Love to see more women's sports. I love to see more pro sports in Boston generally, because right now, with the Patriots and the Red Sox being so bad, we need as many other diversions as possible in this city. However, the marketing campaign that launched this week for Boss Nation is that people should pay attention to the new women's soccer team, because we have in this city, quote, too many balls, close quote. That is a real marketing motto. It went out. It was on billboards around the city for the better part of a day until finally several people started to point out that this was a bad idea. Several people noted that it comes across as a bit transphobic, and I agree with them that it can. I'm just going to focus on the simpler thing that this was just stupid. Who on earth thought that was going to be a clever thing for a women's soccer team? They have since taken down the billboards. They have said that that motto is going away. I don't know what the new motto is going to be, but I mean, way to get a yellow card on your new sports team as soon as the starting whistle goes off. It was just quite a thing.
Mr. Marks.
Wow, that's tough to follow, Matt. But I have one very quick shout out, and then I have another one that I'll get into a little bit more detail. So, going to the women's sports thing, I don't know if anyone's been watching women's basketball lately, but I am telling you, if you're not a fan, you should be. It's very, very exciting. These women are underpaid; they shouldn't be. I'm hoping that really does take off, but they're just absolute incredible athletes, and they should get their just desserts some days. I was reading an article not too long ago, I think it was this week, where one of the women's professional basketball players doesn't even make enough money to pay her rent. And I just think that that's deplorable considering the society that we live in today. But my real shout out is to the anonymous person who solved a 31-year investigation and 11 riddles, and that is the Golden Owl. And I don't know if you know what that is, but I'm not going to get into all the details here, but it started in 1993. And it was a puzzle, and it's been going on. But I think it was a French author, Max. I can't even say his last name, Max V. But anyway, there are 11 riddles, and this thing has been on and off for like the past 31 years. And there's somebody anonymous. We don't know who the individual is, but apparently there's some documentary that's going to come out next April in 2025 that's going to talk more about this. But it's one of the longest investigations that I have ever seen or been a part of. Not personally been a part of, but being a part of actually reading it and trying to understand it. So I don't know a lot about it, but I'm curious to see what the 11 riddles are. And I'm looking to see who the individual was who actually found it. But it was actually kind of crazy because I know people were running around the globe and there were some rules that were put in place, like you're not supposed to dig in on public property or private property without proper approval. But it was sort of this crazy race to find this golden owl that was worth, I think, about $165,000 or $170,000. But nonetheless, a 31-year investigation, 11 riddles, and it's finally solved.
Karen Moore, what do you have for us today?
Well, first, I need a shout out and rave for your doggies. I think they should make more of an appearance. They're gorgeous. I love them. But my rant today is about something super mundane that has a huge effect on my mood, and that is civility in supermarket parking lots. It can ruin what is my happy place, which is the kind of mindless up and down shopping experience in my local supermarket. The parking lot is just full of trolleys that people refuse to take the extra steps to return to their proper place, and pedestrians that don't look where they're going and don't keep to the crosswalk, and drivers who cannot wait the 10 seconds it takes for somebody to back out and instead go racing behind me while I'm trying to swivel my head in 360 degrees. It just creates a huge amount of stress for me and ruins what my, kind of happy place, calm supermarket, what am I going to make tonight for dinner shopping experiences. So just boo, boo, boo on all the people that cannot think about others and watch where they're going, watch what they're doing. Ooh, yes, Matt, if I could shoot those people, I am anti-gun, but I might make an exception.
Well, move to Florida. I think it's legal down there.
Well, I'm going to have a rare shout out to one of the great bodies in jurisprudence and governance, the Texas legislature. And what they did was frankly stunning. There's a gentleman named Robertson, who's on death row in Texas. He was days from his execution date. He was convicted of murdering his 6-month-old baby with something called the shaken baby syndrome, which has now become completely discredited. The prosecutor has withdrawn or revoked or said, we need to not kill this guy. The witnesses, the expert witnesses, have disavowed their testimony. The U.S. Supreme Court said, well, we don't have jurisdiction, so we can't help you. A district court in Austin, well, the reason the Texas legislature gets this shout out is the Republican-run Texas legislature thought this was such a miscarriage of justice, and the state of Texas was about to execute an innocent man, that they subpoenaed him for testimony. And they went to court to have the execution stayed because the Board of Pardons wouldn't stay it and the governor wouldn't stay it. So a district court in Austin stayed the execution so he could give his testimony to the Texas legislature, which I will parenthetically note doesn't go into session until January. The Court of Criminal Appeals, we have bifurcated appellate courts in Texas, overturned the state district court's ruling, but the Texas Supreme Court said, oh no, you can't do that. We're a civil jurisdiction, and we believe the Texas legislature has the right to his testimony should they subpoena him, and they've subpoenaed him. So they have stayed his execution, all because somebody in a Republican Texas legislature, as right-wing nutbags as you can find in America, thought this wasn't right, and they came up with a way to stop this execution. So kudos to the Texas legislature. Kudos to the Texas Supreme Court for at least giving Mr. Robertson a few more days. So, ladies and gentlemen, that was about as much fun as I've had on one of these shows in a long time. Everybody brought their A game. I wanted to thank you all. So until next time, ladies and gentlemen.